In this video, we would like to discuss questions on Hindu Minority and Guardianship Act 1956. So, question number 1: who are natural guardians and what are their powers? Does an adoptive father enjoys the powers of a natural guardian? And question number 2: make a critical assessment whether a testamentary guardian is de facto guardian or de jure guardian. And question number 3: who is natural guardian of a what? What are the rights of a natural guardian under Hindu Minority and Guardianship Act 1956? Can he alienate the property of a minor? Explain. And question number 4: explain the concept of de facto guardian. With the help of decided cases, discuss whether Hindu Minority and Guardianship Act 1956 abolished it. Then question number 5: differentiate between the powers of a natural guardian and testamentary guardian. Then question number 6: discuss the legal effects of conversion on a Hindu guardian as per the Hindu Minority and Guardianship Act 1956. So, as it is asked regarding natural guardians, so the very concept of natural guardians is defined under section 4 of the Act, and here it is being defined as natural guardian appointed by the will of the minor's father or mother, guardian appointed or declared by a court, and a person empowered to act as such by or under any enactment. So, to widely explaining the very concept of natural guardian, as we found a boy or an unmarried girl, in that case the father, and after him the mother. And when it is the child is below 5 years of age, then the mother. And regarding illegitimate boy or illegitimate unmarried girl, the mother after her father. And regarding a married girl, the husband. The natural guardianship ends by ceasing to be a Hindu or by becoming a Banapastra or a sannyasa. And stepfather or stepmother cannot be natural guardian. And as regarding the very adoptive nature of guardianship, natural guardianship of an adopted son who is a minor passes on adoption to adoptive father and after him to the adoptive mother. And regarding the very powers of natural guardian, as it is asked under question number 1, so also the very question number 3, so section 8 of the Act explain about the powers of natural guardian. So, the natural guardian do all acts necessary, reasonable, proper, and for the protection and benefit of the minor. So, without previous permission of the court, cannot mortgage or transfer by sale, gift, exchange, or otherwise any part of the movable property of the minor, and cannot also lease such property for more than a term exceeding 5 years or for 1 year beyond the date on which the minor will attain majority. So any disposal of the property in contravention of subsection 1 and 2 is voidable. So the court shall grant permission only in case of necessity for an advantage to the minor. And lastly, all application for such permission can be obtained under Section 29 of the Guardians and Wards Act 1890. So, before giving any such permission, the court shall follow the procedure and power specified under Section 31 of the Act of 1890. So, also in that case, we could discuss certain leading cases as already we have discussed, like E.M.N. Nadar versus Siddharan 1992, the judgment of Kerala High Court, and Srimati Manju Tiwari versus Dr. Rajendra Tiwari in 1990, the judgment delivered by the Supreme Court. So also in another leading case, and that is case Mohan versus Sandhya Mohan in 1993, the Madras High Court saw several leading cases relating to guardians, natural guardians powers that already we have discussed in our uploaded videos relating to Minority and Guardianship Act 1956, just 2 days before, and regarding the very question relating to testamentary guardian, as it was asked both in question number 2, so also in question number 5, and regarding that, it is a kind of guardian appointed by a will of the natural guardian of the minor, as a will comes into effect only on the death of its executor. So, testamentary guardian becomes functional only after the death of the natural guardian. So, certain persons who are eligible can appoint a testamentary guardian, and they are the natural father, adoptive father, the natural mother or adoptive mother, the widowed natural mother or the widowed adoptive mother. So a Hindu father cannot appoint a testamentary guardian on the undivided interest of the minor in the joint family property, as it remains in the hands of the Karta. So also Hindu father appoints a testamentary guardian and dies, then the mother of the minor shall be the guardian only if she dies. Without appointing a guardian, then the will of the father shall becomes effective. And in case the widowed mother appointed a guardian, then that will come into effect. And where the child is illegitimate, then the mother is entitled to appoint a guardian, and the father has no right to appoint any person as guardian. So Hindu mother has absolute right to appoint a guardian when the father ceases to be a Hindu and becomes a sannyasi by renouncing the world. So, testamentary guardian can exercise all the rights and powers of a natural guardian to such extent and subject to such restriction as are specified in the Act and in the very will. And regarding de facto guardian, the Act does not recognize it. De facto guardian is neither a legal guardian nor a testamentary guardian, and nor a guardian appointed by the court, but he has taken himself over the management of the affairs of the minor as if he were a natural guardian. So he does not have the power to alienate or deal with the property of a minor. And regarding this, we already discussed in our uploaded videos certain important leading cases relating to the very nature of de facto guardian and the very powers as it was utilized by the de facto guardian, and in that connection we had already discussed the important leading case Arabindo Society Pondicherry versus Ramdas Naidu. In 1980, this judgment was delivered by the Madras High Court. So also another important leading case, Dhansekaran versus Manoranjan. In 1992, the judgment was also delivered by the Madras High Court. So also another important leading case that we discussed, Isakalkayal Nadar versus Siddharan in 1992, where the Kerala High Court delivered the judgment on the alienation of minors' property by a person other than the guardian of the minor was held void and not binding upon the minor, and the same alienation of minor share in joint family property was also held illegal in Dhansekaran versus Manoranjan in 1992 by the Madras High Court. So, these are the very brief answers regarding these questions that already we have discussed in this video under the Minority and Guardianship Act 1956 regarding the Hindus with reference to the Guardians and Wards Act 1890.